Before becoming a United States Supreme Court justice and before becoming a federal judge, Justice Amy Coney Barrett was a professor of law, educating people and her students about the Constitution, including the Second Amendment. I have a feeling that one of the reasons why Justice Amy Coney Barrett is very interested in this Supreme Court appeal dealing with Bevis versus the city of Naperville is because she intends to school these Chicago judges and the federal bench that cannot seem to get the Second Amendment right, even though they've been given the answers before the test. Stay tuned. Let's talk about what Justice Barrett, I think, is looking at in this case before her. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and proud author of the new best-selling book, Disarmed: What the Ukraine War Can Teach Americans About the Right to Bear Arms. Huge book. We're going to talk a lot about it later in this week when all this breaking news is behind us. But for now, I want to talk about this pending Supreme Court matter before Justice Amy Coney Barrett. As you know, we talked about this yesterday, and I want to tell you, having looked a little bit more detailed at sort of the facts of the underlying cases, which we previously covered on this channel, by the way, but I want to tell you what I think Justice Barrett and the Supreme Court are looking at. Just to remind you, the name of this case before the U.S. Supreme Court is the National Association of Gun Rights versus the city of Naperville. Okay? The lower court judge, Judge Virginia Kendall, who was appointed to the federal bench by George W. Bush, could not have screwed up the basic rules of the Second Amendment in firearms technology if she tried. And the reality is that the U.S. Supreme Court is almost certainly taking notice of this because Justice Barrett, before becoming a federal judge, remember, she was a professor of law, and of course she was a Supreme Court clerk before that. But as a professor of law, I'm sure Justice Barrett is quite familiar with educating and correcting the mistakes of her students, because that's a big part of what a teacher professor does. You know, you work with students, they get things wrong, you send them back and you help them get it right. So I have a feeling that when Justice Barrett looked at the decision written by Judge Kendall out of the Northern District of Illinois, upholding the semi-automatic rifle ban and the magazine ban where the magazines hold more than 10 rounds, I have a feeling that Justice Barrett read this and rolled her eyes and thought, this could not be more wrong in terms of applying and understanding the most basic rules of the text of the Second Amendment and the Supreme Court precedents, including Heller, Caetano, McDonald, and, of course, Bruin. So I think that the things that are going to stand out to Justice Barrett when she reviewed that opinion is my guess. Obviously, I have no inside information here, and we'll see what the government has to say when they submit their brief, I believe, on May 8th. But the things that stood out to me, and before I get there, I want to say that one of the things that I think the Supreme Court learned from delaying so many years before they made another Second Amendment or heard the Second Amendment is that if you do not nip some of this mistaken jurisprudence in the bud by anti-gun judges in anti-gun jurisdictions, it has a tendency of catching fire and running across the country. Because what happens is judges get it wrong, and then other judges cite to that, and it compounds the error, which is how we had for 10 years the so-called two-part test or interest balancing test where they applied the tiers of scrutiny. And as you know from this channel, because it's my job here at the Four Boxes Diner to make you the smartest person in the room, and I think I can, when you hear the words tiers of scrutiny, you cross it out and you run for the hills, because tiers of scrutiny is a euphemism for the following. It is a euphemism for a judge taking your rights and saying, yeah, you have a fundamental right, but is the government interest to infringe upon it enough to justify it? A tiers of scrutiny is nothing more than the interest balancing test, which the United States Supreme Court said in Heller and then again in Bruin is totally unacceptable in the context of the Second Amendment. And I have a feeling going forward, they're going to start applying that concept, meaning getting rid of the tiers of scrutiny in other parts of the Bill of Rights, but we're not going to talk about that right here and right now. So the bottom line is, here are some of the terrible mistakes that Judge Kendall made that I'm sure that Amy Coney Barrett has already taken notice of. Number one, right off the bat, in her decision in the district court, Judge Kendall actually says that the concept of assault weapon is a perfectly fine phrase and not a propaganda term. Now, she goes on to say that, and this is what she says, quote, I will use the terms as they are widely accepted in modern parlance and effectively convey the substance of the bans. Come on. It isn't. Assault weapons is a political propaganda term. It is not in any kind of parlance that counts, meaning like in the gun community or even the ATF would not be so silly to use those phrases when they're talking about semi-automatic firearms. And we really know, and I think the Supreme Court notices this as well, you know how you know if a judge screws it up when they're talking about semi-automatic rifle bans is if they fail to cite the United States Supreme Court precedent of Staples versus the United States, which clearly draws a distinction unequivocally over dozens of pages, the difference between a fully automatic firearm and a semi-automatic firearm. And Judge Kendall failed, of course, to cite to the Staples case, which just tells you that she is being sloppy, and I'm sure Justice Barrett is noticing that because Staples doesn't appear anywhere in this opinion, which tells you right off the bat that the judge doesn't understand the difference between a fully automatic firearm and a semi-automatic firearm, and the way the Supreme Court views those as fundamentally different types of firearms for many reasons. The next obvious mistake that I think Amy Coney Barrett's going to notice is Judge Kendall saying, quote, the text of the Second Amendment is limited to only certain arms. Okay, that is not true. The text of the Second Amendment is the right of the people to keep and bear arms shall not be infringed. The text, as interpreted by the United States Supreme Court in Heller, basically says, signed to Samuel Johnson, a lexicographer in the 18th century. Lexicographer just means a creator of dictionaries. One of the most famous one is an English guy named Samuel Johnson. The Supreme Court relies on him in a lot of stuff. Says that arms just means something that can be used offensively or defensively, including, by the way, body armor. Body armor. Okay, I know we're not talking about a litigation of that, but that is actually in the definition. So in the text, it talks about anything that can be used offensively or defensively. There is no limitation. To the extent there might be a limitation on the scope of protection for certain arms, that comes in step 2 of the process, which is the history analysis, which you never actually get to in a gun ban case, because as you know what I'm going to say right here, if you're dealing with a ban on firearms or a ban on arms, the only question that matters is that arm in common use by Americans for lawful purposes? If the answer is yes, it's clearly protected. All this other nonsense has no bearing in the context of a gun ban case, which these clearly are in Bevis versus Naperville, because you're dealing with banning the sale, the ban. These are just basically bans, whether it be the ban of the sale or the ban of the possession. Doesn't matter. They're all bans. You are dealing with bans of ordinary semi-automatic rifles and magazines. Therefore, the in common use test applies. And again, if the government cannot prove, remember the burden is still on the government, if the government cannot prove that these weapons are not in common use, it's game over. You don't have to do anything else. And yet the fact is that Judge Kendall runs on and keeps on doing this, just shows you how they're not reading these cases properly. And the Supreme Court has always taken notice, and I know that the Supreme Court has taken notice of these clear errors, because otherwise Justice Barrett would not have demanded that the government submit briefing on these questions. She would have dismissed the request by the pro-Second Amendment plaintiffs outright and say, yeah, go deal within the normal process. But that's not what Judge Barrett did. Justice Barrett actually says, defendant governments, you come in and submit some paperwork, because I think there's no way that she did not read this decision and roll her eyes the way I am. Amy Coney Barrett, I think, is probably far smarter than I am. So if I'm catching it, I can assure you that Justice Barrett and her chambers and her clerks are catching these as mistakes as well. The next obvious huge error by Judge Kendall in this case before the Supreme Court, and it's a no-brainer, is that she quotes William Blackstone, and she talks about dangerous or unusual weapons. Now, this is key. Blackstone, in a context of talking about going out in public to the terror of the people, uses the phrase dangerous or, that's disjunctive, dangerous or unusual weapons in the context of discussing something involving the statute of Northampton. You don't need to worry about that right now. The bottom line is the United States Supreme Court, not only in Heller, but also in Caetano in 2016, if you look at the Sam Alito concurrence, in the United States, they don't talk about dangerous or unusual weapons. It's dangerous and conjunctive unusual weapons. It has to be both. The government has to show that a weapon is both dangerous and unusual to even contemplate the possibility of a ban. which, of course, we're not even getting anywhere close to that when we're dealing with the weapons we're talking about getting banned here, which is semi-automatic firearms, semi-automatic rifles, AR-15s, AK-47s, and magazines that go along with them. There's not even a close call. These are easy cases. But the point is, Judge Kendall is talking about a disjunctive test of dangerous or unusual, but the Supreme Court has repeatedly said that's not true, because remember, the Founding Fathers expanded the scope of protections for the right to bear arms here in the United States, and we made it broader than it was in England. So although we draw a lot of analogies and precedents from English law at the time of the founding, the Americans actually expanded a lot of these individual rights because we are far more freedom-loving people, having just fought a revolution against King George III, and we don't have a king here in America anymore because we kicked him out. And that is why the phrase dangerous or unusual, used by William Blackstone, the English lawyer, is now dangerous and unusual here by the Founding Fathers and the Supreme Court. The next obvious mistake that Judge Kendall made, that Justice Barrett, I'm sure, noticed, is that Judge Kendall talks about how, quote unquote, assault weapons are particularly dangerous weapons and high-capacity magazines are particularly dangerous weapon accessories. Thus, their regulation accords with tradition and history. This is so silly for so many reasons. To begin with, it doesn't matter if AR-15s or semi-automatic rifles or magazines are particularly dangerous, which they're not, but assume they are dangerous, but not particularly dangerous, more so than any other gun. But nevertheless, it's irrelevant because the test is in common use by Americans for lawful purposes, which it is. Game over. Beyond that, the Judge Kendall here talks about their regulation accords with history and tradition. No, it doesn't. How hard is this? Here's the thing. The United States, if you go back and look at the U.S. history at the time of the founding, there are no arms bans. There are no gun bans. Do you hear what I just said? There may be gun regulations, like you can't shoot a gun late at night in the middle of a town square at midnight after people are gone to bed. There might be regulations like you can't use a gun or misuse a gun to commit murder at the time of the founding or today. Yes, there are regulations that govern certain aspects of the use of firearms. But you know what? There is none at the time of the founding are gun bans. So when here you have Judge Kendall talking about the regulation of dangerous weapons, assuming for the sake of argument they are all of what she says they are for the sake of argument. When Judge Kendall says their regulation accords with history and tradition, no, the question is not about their regulation in a gun ban case. The question is whether or not there is historical analogs of gun bans, assuming you even got to that, and there is none, which is why, again, in Heller, if they're in common use, guess what? They cannot be banned. The last point I want to make before I summarize this video is that throughout the opinion by Judge Kendall, she talks about things like there are 5 times the number of people shot with these kinds of weapons. You know, the usual stuff that we saw before Bruin, where there was interest balancing, where the anti-gunners just dumped all this guns are bad stuff, right? Conveniently ignoring all the fact that like 4,000 Americans defensively use guns every single day in America, according to a Georgetown University study by William English, right, which we've linked to down below many times. I'll do it again. The point is, set aside the fact that there is no interest balancing when it comes to the Second Amendment rights, because the interest balancing took place at the time the Second Amendment was written, and the Supreme Court has repeatedly said this. But here you have Judge Kendall talking about interest balancing, trying to say that guns are bad and therefore it's okay that they're banned, but that is clearly not the legal standard. And I just want to say one additional thing, that why I think Justice Barrett is particularly interested in this terrible opinion by Judge Kendall, and that is that you do not want this to catch fire. You do not want to establish these precedents where they can be relied upon. And I'll tell you, just as a side note, I would say it's somewhat amusing if it wasn't just, terrible as a matter of legal reasoning. If you look at the subsequent decision by another United States District Court judge in Chicago, in the Northern District of Illinois, by a Joe Biden appointed judge by the name of Lindsay Jenkins, she upholds a Cook County law very similar to the Naperville law. And in the context of that, she essentially adopts the views set forth by Judge Kendall in the Bevis versus Naperville case, okay? I should note that in addition to Judge Jenkins relying heavily on the Bevis decision written by Judge Kendall, actually Judge Jenkins compounded the error by quoting extensively the McDonald decision by the United States Supreme Court in 2010. The Problem is that the part of the opinion that Judge Jenkins quotes as she discusses McDonald's is not actually from the McDonald's Supreme Court majority opinion, but is instead from Justice Stevens' dissent, which lost and is not the law. So here you have Judge Jenkins, in addition to relying upon the terrible reasoning, as I see it, of Judge Kendall in the Bevis versus Naperville case, but then you have Judge Jenkins taking it to the next level, quoting extensively the dissent from Judge Stevens, which is not even the law of the land, and goes on and does all that. So to summarize, you have a couple terrible decisions in the Northern District of Illinois in these federal district court cases applying the Second Amendment in what should be a very easy case, which is these so-called AR-15 ban cases. Keep in mind that the Supreme Court in Heller says that the gun that's mostly used by criminals is the handgun, and yet that was protected in Heller because it was in common use by Americans for lawful purposes. So there's no way you're going to get a different result dealing with these magazines and or these AR-15 semi-automatic rifles. And yet here you have these judges in Chicago, federal judges no less, are clearly applying the law wrong. I'm sure that Justice Barrett has noticed this, and we'll see whether or not they will step in and do something right now or whether they will let the process play out with a view toward the Seventh Circuit Court of Appeals fixing the mistakes of the district court. Only time will tell, but certainly the mistakes here have caused Justice Barrett, at least, to note, and I'm not surprised as a professor of law before becoming a justice and a judge, that she would be probably unhappy with the result of the writings of these judges, no different than she was probably unhappy with certain students of hers did not get the right answer on her tests. Okay, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.